So we are recording. Peter, if you want to start, then that would be good.
Brilliant. Well, good afternoon, everybody from Dundee. It's a great pleasure to launch the first of our training seminars for the 2022-23 University of Dundee African Schools Mooting Training and Competition. So for those of you who've not met me before, my name is Professor Peter. I'm a barrister, I'm a professor of law at Dundee Law School, and I'm joined today with my great team of trainers led by Kelsey and three new trainers this year. We have Hannah, wave Hannah, and we have Ananya, and we have Ria. And those of you who joined last year will recognize Kelsey, and they will be leading on the training over the course of this semester and will be helping me with judging the internal competition, which will take place in January, and then the international competition, which will take place this academic year in March. So it's great to see so many people join us live. I know many people will be watching the recording of this introductory seminar on Introduction to Law. I would say in the chat, do put down which school you attend so we can see how many of our great network of schools are represented live today. Any questions, put them again in the chat and we'll answer those questions at the end once Kelsey and the team have finished the presentation. So let me pass over to Kelsey and the team, and I look forward to joining you over the course of this semester, and indeed to seeing some of you in person, because I'll be going to Nigeria in 2 weeks' time and then to Ghana in 3 weeks' time. So Kelsey, over to you.
Thank you, Peter. Yeah, I'm really looking forward to this semester and kind of seeing all the new kind of mooting talent and everyone getting involved, and hopefully it running as smoothly and hopefully maybe more smoothly than last year. But the level of mooting last year was so incredibly high, and we really hope to repeat that and kind of make sure we can help as much as possible to all the students that are watching. So I'm not sure if Libby has any quick, I can't remember the words like.
I was just housekeeping. Thank you very much, Kelsey. Thanks, Professor Peter. I just wanted to remind you all that for questions, and we welcome questions throughout the session, if you can put those questions in the Q&A box rather than the chat, please introduce yourselves through the chat function. But if you put your questions in the Q&A, then we can tick them off as we go, which is really helpful. Back to you, Kelsey.
Thank you. So we've just got a quick presentation today about an introduction to law. And basically, if you have a question, feel free to put it in the Q&A. Don't worry about kind of keeping your questions to the end. We want to make sure that everyone is following what we're talking about today, especially because many schools don't teach law, so you might be very unfamiliar with the stuff that we're going to be talking about. So hopefully everyone can see my slides. Hopefully. So yeah, today we're just going to be doing an introduction to law. Sorry, I'm having a slight slideshow issue. Okay, so as Peter's already introduced, we've got 3 new team members this year. And if maybe people just want to introduce themselves and say kind of what year they're in, and maybe what the words like dual qualifying and like maybe what course they're doing. So I can go first. I'm a 4th year Scots law student. This means that I only learn law based in Scotland, although I have done English criminal law. So if you have any questions, maybe about English law, maybe I'm not the one to ask, basically. But yeah, I'm in my 4th year, which is my last year. So yeah, I hopefully know all the modules and can answer a lot of questions. Want to go next?
Right, I'll go next then. So I'm Hannah. I am a 2nd year English law student. So as an English law student, that means I do modules relating to the law in England and Wales. So I don't know too much about Scottish law, but great that we have a team that seems to know Scottish law better than I do.
Okay, so pass on to Ria and Ananya to introduce themselves just briefly.
Hi, I'm Ananya. I'm in my fourth and final year. I'm doing a dual qualifying degree. So that just means I'm doing both Scots law and English law. And yeah, so if you have any questions about either, I know both pretty well. So yeah.
So, hi, I'm Ria. I'm a second year on the same degree that Ananya is doing. So I've done probably about half or just under half the modules that she's done. But I can also answer any questions to the best of my ability on English or Scots law.
Amazing, guys. Okay, so here are the learning aims of today's lecture is to understand what constitutes law. What does law mean? What do we refer to when we mean law? And we're going to explain how the law in England and Wales is made. We're also going to distinguish between civil and criminal law and also touch on a couple other areas of law, because law can cover all sorts of areas of life and you'll come across many different ones, and there will be some overlap as well, but we're just going to try and break it down into the easiest understandable way we can. And we're also going to grasp the general structure of the courts in England and Wales. There is a hierarchy into which courts can hear certain cases, and we're going to tell you about that and how the appeal system works. And we're also going to learn some key terminology. So if there's a word that comes up in this PowerPoint, please don't be afraid to ask what it means. Okay.
Perfect. So I'll just make a start on what is the law. So there's so many definitions, and I'm sure we've heard of the word law, but for me, I'd like to remember the law as a system of rules that regulate or control the behavior within society. So the law helps us, in a sense, control what we do in society by judging it on whether it would be acceptable in public or whether it is unacceptable. So laws can help control behavior in several areas and environments, such as employment. So in employment law, it would help determine how I should act towards my boss or towards my colleagues. There's immigration law, commercial, so helping two business partners who are wanting to, uphold the contract. There's human rights law. So England and Wales, they follow a common law system, which means that the law can be found in cases, so case law, or legislation. So let me first focus on case law and what that means. So case law essentially is law that is created by judges in a court. So they are decisions made by judges in a case. So a court must follow and apply the decision of higher courts. So as Kelsey briefly mentioned, and we will touch upon later, is that there is a hierarchy. So the decision in a higher court, such as the Supreme Court, would be binding or would have to be followed in a lower court. However, case law can be overruled, which we will explain in the section on hierarchy of courts. Secondly, there's legislation. So legislation concerns the parliament. So the parliament, just a very quick recap, is made up of two chambers. So there's the House of Commons. So these are the elected MPs or politicians that we may see on the TV. And then there's the House of Lords, individuals who aren't elected. So they both can create legislation. So the process would be that a bill, so every single law that is passed starts as a bill. So the bill goes through its processes. First, it is passed through the parliament. So as you can see, House of Commons, House of Lords, and it must receive royal assent. So every single bill that has been passed will receive royal assent, which is essentially the monarch. So right now the king, in a sense, accepting and approving that the bill will become a law. So then it will then be enforced in public. So legislation can only be removed if another piece of legislation repeals or overwrites it. So a legislation can be repealed. For example, if there was a law that was created saying people cannot eat out in public, let's say. So that was passed last year. Suddenly, tomorrow, I decide I'm going to pass a law that says, right, everyone can eat out in public. So then the previous legislation that was created would not be enforceable in public anymore. So it would be repealed, or it can be overwritten. So that's how law can be made. And I'll pass it over to the next person if there are no questions about this section. Perfect. I see no questions, so we'll just move on to the next person.
Hi, everyone. So today I'm just going to give quite a short summary about 5 different branches of law: criminal law, civil law, public law, contract law, and tort law. So firstly, criminal law prohibits conduct which threatens or harms individuals or the public. So anything that you might do which could hurt somebody else or a member of the public. That individual would then be investigated by the police, charged with an offence, for example, theft, and is prosecuted by the Crown's Prosecutor's Service, and that can be often abbreviated to CPS. So cases are named in the format of RV and then the named defendant, but you wouldn't say it that way. It would be said instead as the Crown and the defendant's name. So if the defendant's name was Hannah, it would be the Crown and Hannah. And R in that case stands for Rex or Regina, which just means it's another word for the Crown. So those cases are then heard in front of either a magistrate or a jury, and in the magistrate's court or the Crown Court. And there'll be more on the courts in the hierarchy of courts section. The Crown is the one that has the burden of proof, which means that it's their responsibility to show that the defendant is guilty beyond a reasonable doubt, beyond which somebody could reasonably think they'd be guilty of the crime. And that defendant would then be found as guilty or not guilty, which you'd see as acquitted. So separate to criminal law, there's also civil law, which regulates disputes between individuals and provides remedies where there's an interference with property, rights, or interests. So civil law is more about 2 people and their dispute. Civil law can include contract, it can include family, property, and also tort law. There are usually 2 parties involved in a civil dispute, and they're given the names claimant and defendant. So the claimant is the individual who would bring the claim, and defendant is the one who would be defending the claim. These cases are then heard in front of a judge, or it could be a panel of judges, depending on the court, but no jury. The judge decides who is liable and who is not liable on the balance of probabilities, which is a different burden of proof to criminal law. So in public law, which is another different branch of law, that regulates the relationship between the state or public bodies and individuals. So public law would be constitutional and administrative law, things like human rights. The state gives authority to public bodies to carry out responsibilities on their behalf, and a public body could be a government minister, local authorities, health authorities, police, etc. And if a public body acts unlawfully, the people that are affected can challenge that behavior or decision through mechanisms created in public law, such as a complaints procedure, appeals, or judicial review. So these 2, both contract and tort, are underneath the general title of private law. So contract law arises out of voluntary agreements to create rights and obligations between individuals. So disputes can arise regarding intention to create a contract, breach of contract, termination of contract. So those kind of phrases would mean what the parties wanted when they made an agreement, and something that's gone against that agreement, and then ending that agreement. The court can remedy this by awarding damages, so that could be monetary, so that could be money, or ordering enforcement of the contract, so forcing the parties to go ahead with what they agreed they were going to do. And tort law is individuals who have suffered as a result of a breach of a protected interest. It's worth mentioning that in Scotland, instead of tort law, this is called delict, and these 2 different laws can have differences between them. But for tort law, negligence is a tort which concerns damages caused by a breach of duty of care. A duty of care is the level of care that you owe to somebody else, for example. Damages can be sought for injury, property damage, economic loss, or psychiatric harm. And the court can remedy this by awarding damages by either ordering a specific action or ordering an injunction to prevent the action.
Right, so what you see in front of you is the court system or the court structure in England and Wales. This is the hierarchy we were talking about earlier. On the left-hand side, you've got the criminal side, the criminal division, and on the right, you have the civil division. So we'll go through the criminal side first. So if you look at the very bottom, you have the magistrates court. Now the magistrates court is at the bottom of the tier for criminal division cases, and it generally deals with lower tiered crime like theft or breach of the peace. After that, you have the Crown Court. They deal with more serious crimes. We're talking crimes like murder, attempted murder, sexual assaults, robberies, and the decisions that the judges make in both the Magistrates Court and the Crown Court can be appealed if the losing party is unhappy with the decision. And if it is appealed, the case is heard in the Court of Appeal Criminal Division. Now, once it's heard in the Court of Appeal, it can also be further appealed and it can be heard in the Supreme Court. Now, the Supreme Court is the highest court in the UK. It hears cases from England and Wales, as well as the developed administrations of the UK. So, for example, it can hear cases from Scotland as well, even though it has a separate legal system from that of England and Wales. Now, on the right-hand side, we have the civil division. So at the very bottom, we have the county court. Now, the county court generally deals with lower value cases relating to lower value damages. So we're talking about cases like debts or lesser personal injuries. After that, you have the High Court of Justice. Now that it has three divisions. There's the, I believe that should be the King's Bench now. So we have the King's Bench, Family, and Chancery. Now, under the King's Bench division generally deals with cases of more serious personal injuries, human rights breaches, and defamation. Those are just a few examples. Family deals with family law. So we're talking cases of like child abductions, divorce, custody, and with the Chancery division, they deal with disputes relating to business, property, IP, and a lot of wills and trusts. Now, again, similar to the criminal side, a party who's unhappy with the decision of the court, they can choose to appeal either the county court or the High Court of Justice's decision. And if that happens, the case goes up to the Court of Appeal. And if they want to further appeal, it goes up to the Supreme Court. Again, on the civil side, the Supreme Court is the highest court you can appeal in. And essentially their decision is final. So whatever they decide, whatever the judgment is, it's enforceable on both parties. And you don't have any further courts that you can go to for appeal. So that's the court structure in England and Wales. Right, and now you have two different kinds of courts. You have the court of first instance and you have appeal courts. Now, first of all, the magistrates court and the county court, they're generally the first, they're usually the courts of first appeal. And what this means is that they're essentially courts where legal proceedings are first brought and heard, and the court used will depend on the seriousness of the offense in cases of criminal law or the value of the damages in civil law. So what that essentially means is that if you have a criminal case where there's a more serious offense, instead of it being heard first in the magistrate's court, it'll go straight to the Crown Court, and that will be the court of first instance. And the same thing applies to the civil division as well. If you have a more complex or more serious or essentially a case that has a higher value of damages involved, instead of hearing it first in the county court, it'll go straight to the High Court of Justice. And then second, you've got the appeal courts. So again, if a party is unhappy with their decision of the court, they can appeal it. The case goes to a higher court, which is the Court of Appeal, and then the Supreme Court above that. And that's usually the hierarchy that it follows. Now, an appeal can be on the basis that the decision of the case was wrong or unfair due to procedural error. This just means that you can't appeal on the basis of facts. The facts are generally established in the lower courts, and those facts are essentially followed through the length of the case and up the hierarchy as you appeal further and further. And a few examples of why some of the grounds that a party may choose to appeal on would be appealing on the basis of sentences that a judge might give out, or based off convictions or child custody cases. Those are just a few examples that we see on a regular basis. Now, An appeal court can either affirm the previous judgment, that just means that they agree with the previous court's judgment and it remains enforceable. They can also substitute it with their own judgment, so that just means that they disagreed with the previous judgment of the court and they share their own judgment, and that's what's enforceable on both parties. Or they can choose to remit it to a lower court for further procedure. This just means that the case is sent back to the lower courts and it's tried generally from the beginning, and then, you know, it can go higher up the ladder in terms of hierarchy. Now, oh yeah, judicial precedent. You're probably wondering what judicial precedent is. It's just a core doctrine of common law systems. The UK is a common law system. And I mean, you can define precedent as a history of judicial decisions which form the basis of evaluation for future cases. In other words, kind of like how Hannah put it, it's just a statement of law by a court which binds other courts of equal or lesser importance, and the court must always follow the judgments of a higher court. So if the Supreme Court puts out a judgment, that's going to be binding on all the courts below it. Now, what's the purpose of judicial precedent, right? So the purpose is essentially to provide certainty in a common law system, since courts must consistently apply legal doctrines where the facts or circumstances are similar. Now, as we learned earlier, legislation from the Parliament isn't the only source of law in the UK. We also have case law. Case law generally arises from previous cases where judges have binding judgments, and it can also come from the way judges interpret legislation in cases. Now, the problem with that is that legislation can be interpreted differently by different courts. So having judicial precedent makes sure that the courts don't have unlimited interpretations, and that there is consistency in judgments of like similar cases, and that have similar facts and similar circumstances. Now, besides binding judgments, you also have something called persuasive judgments, and that's essentially decisions of a lower court or another jurisdiction that are persuasive because they still contain relevant legal principles. Now, that just means that you can use case law or judgments from lower courts. So, for example, if you're in the High Court, you can use judgments from the county court, simply because it has relevant legal principles, and then it's up to the court to consider it. And another example of that of persuasive judgments is, suppose a case is being heard in England and Wales. If you use a case or a judgment from Scotland, that would be persuasive because it's a different jurisdiction, but it still may contain relevant legal principles, or it may be worth noting. They might just have more modern legal principles that they're applying, or a more modern outlook, or a less appropriate one to that particular circumstance of the case. So yeah, I think we can move to the next slide.
Okay, so here's some terminology that we thought was kind of relevant for you guys to know and have in each PowerPoint. At the end of each PowerPoint and lecture that we will be doing, there'll be a different kind of set of terminologies. So by the end of this, hopefully, you'll basically be a walking, talking legal dictionary. So we've mentioned magistrate a lot. It's a very uncommon word. I don't even hear it that often, especially in Scotland, because we don't have a magistrate's court, but it basically just refers to the judge in a magistrate's court. That's just their official title, is the magistrate. They don't actually need to have a law degree or kind of be an official lawyer or judge, etc. So that's what the word like lay justice means. It just means kind of normal, average person. They usually get appointed. In common law, we've talked about a lot. So England is a common law system, which means that most of their most of their law has previously came from case law. However, we are seeing a lot of legislation now. So most of the moots that you guys will be doing will rely on case law as a source of law. However, there will be some legislation in there as well, but we just say that England is a common law system. And here's some Latin for you guys. So we've got ratio decidendi, which means the reason for the decision. basically, if you're quoting a judge from a judgment and you get to the bit where they're like saying their legal principle, usually that's referred to as the ratio decidendi. And then we get something called obiter dictum or obiter dicta, which means that it's still part of what a judge has said in their judgment, but it's not actually referring to part of their legal decision. So if you're using it in a moot, it's not considered binding on the court or kind of a source of law. So then we've got stare decisis, which means to let the decision stand. So this is kind of the principle for our case law precedents. And it just means that the legal decisions of higher courts that have already been heard are binding on lower courts that are hearing new cases. And then we've got this word distinguish, which is quite important. So if you're saying to a judge that you have a case and the facts of the case are not similar to the one that's being heard, you can say that while this case would be binding, we have to distinguish it in this instance because the facts are not similar and we can't apply the same law in the same way. And then we have lastly, jurisdiction. So it just means the authority that a court has. You may also have heard of jurisdiction in terms of state and countries and boundaries. Specifically in a legal sense, jurisdiction just refers to the ability of a court to hear cases. So for example, Ananya's talked about how the Crown Court has jurisdiction to hear I'm getting confused. The Crown Court? The Magistrates Court has jurisdiction to hear lower level criminal offences. They don't have jurisdiction to hear cases such as murder or treason. So that's their jurisdiction. Jurisdiction can also refer to a court's ability to hear cases within a certain area. So there'll be lots of magistrates courts in Scotland, not in Scotland, in England, and all of them have a kind of different geographical jurisdiction. So yeah, that's terminology. So hopefully you guys have got given some textbooks last year. I've got the names of them later on in some reading, but the textbooks will be really useful for you guys in terms of finding legislation and cases. So if you go to the front of the textbook, I think it might be before or after the contents page. It is right at the very beginning. It'll have a table of cases, so you can look alphabetically and try and find the case or legislation that you're looking for, and it'll give you the page numbers about where that case or legislation is spoken about within the textbooks. So it's a really helpful place to start if you're looking for a case, rather than just you kind of reading, tens or hundreds of pages trying to find the case that you're looking for. If a case isn't in the table of cases, then it's not in the book, unfortunately. And we've just got some recommended reading here. You don't need to do all of it. It's only if it really interests you, but it'll kind of go into a bit more detail about the stuff that we've spoken about today. So these slides will be circulated and this recording will be made available, but I can leave this slide on if people want to maybe take a photo of it. But as I said, it will be made available, so don't worry. And this reading, again, isn't mandatory. It's just if you want to learn a little more, you can kind of see maybe some more examples or some kind of laws in practice. So yes. And finally, we've just got some questions that we want you guys to answer and try and get you involved. So we will be covering the answers to these questions in next week's lecture. We might try and set up a little Menti and get people to submit their answers, but try not to get kind of overwhelmed if you don't know any of the answers. Just try and cover as many as possible. So yeah, and some of them have actually been covered today. So hopefully if you're paying attention, you know what the answers are. So what's judicial precedent? What is a law report? How important are cases as a source of law? And are some cases more important than others? We want you to also find the case of Donoghue against Stevenson. I've given you a hint here. You can find it in your tort law textbook. Maybe use the table of cases I spoke about, and just a couple supplementary questions about what are the facts of the case, the outcome, the ratio decidendi, and whether you personally agree with the decision that was made. And then just how many judges are currently sitting in the Supreme Court? So we've got a question that's came to us that says, does the UN Charter contain all the laws that are used in all the countries? Does anyone know anything about the UN Charter? I don't believe it's binding law. I know that the UN has a General Assembly, and the General Assembly is able to like make treaties and conventions with other countries. So for example, one that I can think of was, oh my God, can I think of any? I can think of one, I think there's one called the Aarhus Convention that was a General Assembly declaration or kind of treaty, and it was then adopted by the countries, but it is generally up to the countries themselves whether or not they implement that law into their system. So it's usually the case that international treaties or conventions aren't necessarily binding law on every jurisdiction unless they actually write that law into their legal system. For example, the European Convention on Human Rights, we have written that into our law. So we've got the Human Rights Act. So hopefully that answers your question. If not, I will Google it and I will hopefully tell you next week what the answer is. Okay, so there's another question here about the structure of the mooting competition, and what's it going to be like, and how are we going to be assessed, and are we expected to familiarize ourselves with the UK law? So the structure of the mooting competition is that you will be there'll be an internal competition first, which will be, I think it's 4 people can be in a team maybe, and the internal competition is basically going to decide, oh no, it's more than 4 people, and the competition is going to decide who the 2 or 4 main people that will represent the schools in the international competition. I do believe that some kind of information has maybe went out into terms of the teams. I think Libby could tell you more than I could. But in terms of
just to jump in as well, so if there's only 4 students who are involved in mooting in the individual school, it's a chance to practice and to work out who the best 2 speakers are who will speak at the international competition. If you're in a school where you've got lots of people involved, it's to work out which members that are involved in the mooting will go forward to represent the school, which 4 students.
Thanks, Peter. Your answer was much more cohesive and organized than mine was. Okay, so how you're going to be assessed, there's certain criteria in a moot that usually is looked at. So we've got things like, how was your organization of your argument? How was your ability to answer questions from the judge? How was your legal knowledge? How was your team working? Did you refer to your teammates' argument maybe? So hopefully that answers your question. I think we'll be sending around the marking scheme that we use, but it's very much, there are various elements that we can look at. So you can do very badly on one thing, but very well on another. And you're not totally expected to familiarize yourself with the UK law. We'll be sending around, or I think it's already been made available, a judgment pack. So we will give you all the resources you need to research the moot, and you are limited to those cases. However, you have to decide how you use them, which ones you use, and how to kind of build your argument around that. And yeah, you are expected to kind of know the general structure of the UK courts, like we've been over, so that you can answer questions based on whether or not a case is binding.
Yeah, thanks, Kelsey. Just to reiterate that the only material that you will use is the material that we have sent you. That's it. There's no additional research to undertake. So it's the material that we send you. That's the material to look at, to consult, to analyze, and to apply in the best way possible to support your arguments, either for the respondent or for the appellant in the moots that you have. So it's really, really important not to take into account anything else. You just rely on the material that we send you. And in terms of the mooting, the marking, we'll send you a copy of the marking sheet. Each moot is graded out of 100 points, 40 marks attributed to the junior counsel, 40 to the senior counsel, and then 20 for 2 categories based around teamwork and the overall performance. So for each moot, you get a score of 100. Each school moots twice in the international competition. So the total score is out of 200. Whichever team has the highest score out of 200 gets the mooting trophy. And there's also a prize for the best individual mooter, the mooter who gets the best score out of 40 in one of his or her moots.
Okay, we've got a couple more questions here. I'll open up to my other mentors if they maybe want to answer them, but one of them is kind of explaining the legal effects of the exit from the UK on the European Union. So does anyone want to answer that? The quick answer is we're not going to ask you anything about the European Union, and we're not going to tell you any law from the European Union. But if you do want to know more, we can happily answer or try and answer that question. Ria, Ananya, no?
This probably wouldn't be, honestly, I don't quite know much about. It's not exactly something that I've done a bit of research on myself.
That's okay. It's a hard question, so let me jump in. So the exit from the European Union has had a huge effect on the many aspects of the legal system and many individual areas of law applicable in England and Wales, and indeed in Scotland. So if I can refer to my own area of law, my area of law is called private international law, and that is the set of rules that apply to any private law dispute that has an international element. So an international contract, an international accident, an international child custody case, an international divorce. And whilst the UK was part of the European Union, the UK was subject to European Union rules that really provided a very sophisticated and integrated system for dealing with all private law cases with an international element. And they meant that every country in the European Union, all 28 then, applied the same rules as to when to hear a case, same rules as to what law should apply to that case, and indeed the same rules as to when a judgment from another EU country should be recognized and enforced. And the consequence of those rules was that there was, in effect, the free movement of judgments between the 28 member states of the European Union. Now, because once the UK left, it's meant that the UK is outside of that special club promoting the free movement of judgments. So it has had really a dramatic effect. So Kelsey did my course in private international last year. So she saw how the UK went from being part of this sort of Rolls-Royce system, making it very easy for litigants to have their judgments recognized and enforced, to one where it is more of a second-hand Ford that's really quite old, where it's much more difficult to have judgments recognized and enforced. So in my area of law, private international law, the exit from the European Union has had a dramatic effect, and it is a negative effect, unfortunately. There are lots of other areas of law where many changes have been made. Some people might say some are good, others are less good, but really in private international, it's sort of an unknown area of law for many ordinary people, but one where the consequence of EU departure has been really significant. It's as if the clock has turned back 40 years for the UK in terms of how it deals with these international cases affecting people in contracts, in accidents, torts, in divorce, and in custody. So not really a good thing for us. What's the next question, Kelsey?
It's how will we be able to cope up with the situation of a judge making a biased decision? I mean, the quick answer is we're not going to be biased, don't worry. We very much don't come into the moot with a decision based on who's going to win, depending on the side of the law. This is quite an important thing. When we moot, we're not looking at it in terms of if you have the weaker side of the law, you're going to lose. It's very much looking at how someone organizes their argument and speaks it in a confident, clear manner, and can engage with the judge whilst being asked questions and be able to kind of answer those questions succinctly. So it's very much not based on the law, even though you're talking about the law.
And it's very important to respect the rules that we will give you as to how you should conduct yourself during the moot. So it's mooting is a very serious, sober undertaking, just as it would be if you're appearing in court. So it's always important, it's essential to be respectful at all times to the court, to your opponents, to the judge, to act in a very, very serious way. Give you one example: one would never moot and chew gum at the same time. That is a big, big no-no. You would certainly, if you did that in court, you wouldn't last long as an advocate, and certainly that's not something to be doing when you're mooting either.
Actually, in light of your answer to that, we do have another question which is related, and which is about accents and intonations. So would someone be judged by their accent or on their intonation whilst they are presenting?
Key thing is clarity. Kelsey and the team will be talking about delivery in a couple of weeks' time. It is so important that the judge, the court, understands what you say, can follow what you say, and for you to modulate your tone and your pace so you can emphasize different parts of your submission. So accent, not a problem. I've got an Irish accent. It never held me back. The key thing is clarity of delivery and clarity of presentation.
And so we've got a question here about how long, according to you, should a person study law? And so I'm doing Scots law, which is a 4-year degree. However, Hannah's doing English law, which is a 3-year degree. And if you came to Dundee doing an English law degree, you'd be doing 3 years. And then there's like qualifying into law, but that's not at university. But you can also do a master's in environmental law and financial law if you're interested in that. People can keep studying law forever if they want.
9 years. So I did a 4-year degree in law and French, then I did a PhD over 4 years, and then I qualified as a barrister. So yeah, 9 years. Eternal student. Any more, Libby?
Thank you. Yes, we have another few questions. One of them is about materials. So I think I can probably answer that. What if we haven't received the material that you have sent us? So if your school has said that they want to be a part of this competition, then we have sent all of those materials on. Please do speak to your teachers, and if they haven't got the materials, then they can certainly get in touch with us and we can send those on again. You won't be asked to rely on material that is not within any of the packs that we are sending for the competition. And so that kind of, you won't need to rely on anything else other than what we're sending you. There is a question from one of the students who asked a question earlier, saying, how is UK law related to Kenyan law?
So I'll jump in and speak to that one. So Kenya, like the UK, like England, is a common law legal system. Consequently, there are some similarities in the structure of the legal system and the way in which the law has evolved. So anybody wanting to practice law in Kenya as an advocate, as a solicitor, could undertake an English law degree, such as at Dundee, and then return and go to the Kenya School of Law to complete their qualifications to qualify as a lawyer in Kenya. So many similarities, but obviously the individual terms of Kenyan law are different, but there are similar origins and a similar approach to the study and application of law. I see the next question is about philosophical and analogous arguments. Answer to that, very, very simple, no. You argue on the basis of the law using the materials that we have provided you with. So it is a legal argument only.
One more question is about an internship program. Peter, I don't know if you want to take that one on.
Yep, so to qualify as a lawyer in the UK, whether in Scotland or in England, it is essential that students apply for vacation placements that are organised by leading law firms if you want to stand a chance to qualify as a lawyer. We give lots of support to our students to prepare them for those interviews, for those application processes. So that's something you'd apply for. if you wanted to qualify as a lawyer. And some of our students from Kenya and from Nigeria have indeed been very successful in doing internships last summer. We'll have a story about that on our website very, very soon.
And there is another question that's kind of relating to the one before, which is about applying UK law when mooting in Kenya. And I think the answer is that the mooting problems that you will be given will be based on UK law, will be based on English law. And you will be given all of those materials. So you won't be asked to go and research law in your own country and use cases from that jurisdiction. You'll be expected to use the materials that we are providing.
Yeah.
And I think that's all the questions answered so far. Are there any questions or comments that come to mind from either yourself, Professor Peter, or from any of the tutors here, the mentors here? So if you have anything that you think is important for the students to know at this stage.
Yeah, no, that's some great questions. Key thing is to keep asking those questions. That's why we have these sessions. Do follow up and do the reading that Kelsey and the team have suggested. It's super important, especially if you're not studying A-level law at your school. I would reiterate that there's absolutely no disadvantage in not studying law at present, because the winners last year, Aga Khan Nairobi, they're an IB school, they're not doing law, and they won the competition with excellent mooting. So read the materials, look at the book chapters that we've given. You now have all the mooting packs that you can consult as well, and follow the seminars that Kelsey and the team will be running over the coming weeks.
Fantastic. Well, if we have no further questions, then I think we'll wrap up this session. And I will upload this recording to YouTube and send a link on to all of the schools that are participating. You'll be able to download and look at that in your own time. If you do have any further questions in the meantime, then please do ask your teachers to get in touch with us. They have my details, they have Professor Peter's details. In fact, they have all of the tutors' details. So let us know and we can certainly get back to you with any answers. But from us all in Dundee, we wish you well. And we look forward to the Mooting Lecture 2, which will be next week. And I will send the link on to register for that by the end of this week. Take care.
Brilliant. Thanks, Libby. Bye, everybody.